Hello and welcome to Talks on Law. I'm Joel Cohen. Today, our guest is Scott Anderson. He is a fellow at Brookings Institution and a senior editor at Lawfare. Scott, welcome.
Thank you for having me.
Today, we're talking about how the world is filled with peace and there's only harmony all around us.
There you go. Well, that would be a less interesting episode than what we probably have planned, I think.
Okay, so we're going to talk about something that I'm personally fascinated by. We've gotten some questions about, which is, what is the law relating to targeting, arresting, killing, kidnapping a foreign head of state? Obviously, this isn't purely hypothetical. We have the recent news. Maybe you could give our viewers who are living under a rock what has happened in Venezuela.
Sure. I mean, we've had a tumultuous couple of months, to say the least, in regards to U.S. policy towards Venezuela. We've had several months of maritime strikes against narcotics traffickers in the Southern Caribbean and Eastern Pacific, that many of whom have been, but not all of which have been tied back to Venezuela because of alleged ties between the narcotics trafficking organizations there and the Maduro regime that has been in de facto control of Venezuela for the last several years, although not the recognized government by the United States, notably. Then on January 3rd of this year, we saw the Trump administration pursue a pretty audacious military operation that captured Nicolás Maduro, brought him to the United States along with his wife for prosecution in the Southern District of New York, which is now ongoing, ended up killing an estimated roughly 80 individuals in Venezuela because it was, while there is being framed as a law enforcement operation, there's a strong military element of it, including a number of advanced strikes and subsequent strikes intended to help ensure the safe removal of Maduro and of U.S. personnel involved in that operation. And now the Trump administration has, since that operation, says that it is effectively, quote unquote, running Venezuela, has been particularly active in trying to resurrect and set the stage to reconstruct Venezuela's oil sector with the apparent cooperation of Maduro's successor, Delcy Rodriguez, who was his vice president, has now been sworn in as at least the interim president for Venezuela. So that's about where we are now at this point, I think.
Okay, so we've got quite a lot to cover. I hope we can get through all of it. But before we get into it, I want to just kind of set the stage a little bit. This is going to be talking about not legal. We're not going to be talking about political judgment in this conversation. We're going to be talking about whether this is smart politics or smart policy. We will be talking about how the law treats actions like this, and to get a better understanding of when and how can states target other heads of states, or what protections are in place. So I guess maybe before we jump in, did this all hit you as a surprise when you woke up? Was it a Saturday morning when you saw Maduro's on a helicopter or a boat?
Yeah, it definitely was a surprise, I think, for two different reasons. One, there's always this question as to whether the Trump administration would follow through on its increasingly express and explicit threat to use military force directly against Venezuela. It had targeted all these narcotics trafficking vessels in the international waters around Venezuela, had purportedly authorized covert action against Venezuela and pursued one or two measures there, but it hadn't done anything directly against Maduro or the regime of a substantial scale up to that point. So that was surprising that it took that exact step. I, for one, was admittedly dubious that they were actually going to take that step at a certain point, but obviously was wrong about that. And then also the nature of the operation is really interesting. I mean, they are effectively trying to engage in extremely light footprint regime change, where the idea is that, well, we're going to assert the ability to dictate the policy direction, at least on certain key issues that we care about with Venezuela, but we're going to do it with a very, very light footprint, a military operation that only lasted 3 hours, involved U.S. military and law enforcement personnel in country just for a couple of hours, removed Maduro and his wife, but basically left the regime otherwise in place. And the assumption that they're operating under is this idea that they'll be much more pliant under this additional leadership and make the concessions the Trump administration wants to see. That is an interesting approach, very different from regime changes that the United States has pursued in the past, whether in Panama, whether in Iraq. And so I wasn't surprised to see the administration take a low risk kind of light footprint approach, because that is its kind of inclination in these things. Its appetite for major overseas military undertakings is not substantial, and its political support, even within its main constituency, I think is fairly limited for that. But the Trump administration, President Trump himself, have threatened that as a quote unquote second wave afterwards if things don't go the way they want them to go in Venezuela. So that possibility is still on the table. So yeah, long story short, it was a turn of events I didn't entirely see coming. Although I will say, I thought if it was going to happen, it would look something like this. So
all right, so
I'm
you
not
weren't
entirely
as
surprised to some degree.
gobsmacked as the rest of us when we check the New York Times or
Yeah,
whatever.
most of the way there, 80% of the way there at least. But.
So I guess to frame the conversation, maybe the crystallizing question is, why is targeting a head of state different, or maybe even is it different under legal regimes?
It is, although maybe the biggest difference there isn't that different from targeting a head of state versus targeting a foreign state generally. So under international law, it's worth noting generally the use of force between states is prohibited. The UN Charter does it expressly. It is arguably reflecting a peremptory norm of customary international law, an idea that this is the way international law has evolved, and it's accepted widely by states. With subject to very limited exceptions, the main ones being the authorization of UN Security Council, which obviously did not occur here, and then the quote-unquote inherent right of individual or collective self-defense, end quote. That is from Article 51 of the UN Charter, and it's the only really express exception that the UN Charter carves out, saying we're not intending for this prohibition to interfere with this right of individual or collective self-defense. And then there's a debate about what exactly that means. So just attacking another country itself raises big legal questions. In theory, it's supposed to be, if it's not UN Security Council authorized, it's supposed to be within that umbrella of inherent right of self-defense articulated in Article 51. The head of state.
Here were we seeing some justification for that in the kind of lead up when there was language, war on these narco traffickers, or we're at war with these smugglers when we're blowing up the boats.
Yeah, we saw an express Article 51 argument be made in regards to the maritime strikes that predated the January 3rd military operation. The Trump administration had essentially argued that the narcotics organizations in smuggling narcotics into the United States and engaging in some constellation of other sort of criminal hostile activities, but of a relatively low scale, including maybe migrant trafficking, including maybe some violent criminal like gang activity, collectively amounted to an armed attack on the United States. And that's important because under Article 51, that's when the inherent right of self-defense begins to apply, is when you're responding to an actual or imminent armed attack. The text actually just says an armed attack, but it's been interpreted widely to mean actual or imminent. That's a pretty controversial assertion by the Trump administration, both in the eyes of the rest of the international community and from the lens of past U.S. practice, because traditionally the United States has maintained that to be an armed attack, something has to have kinetic effects similar to what would arise from a bullet or a bomb, or what people would think an armed attack means in 1945 when they wrote and signed the UN Charter.
Which is harder to claim with cocaine.
Well, the UN Charter, you have to remember in mind, the whole idea of the UN Charter is that we want to limit states' ability to resort to the use of force for any sort of international law violation. We want to reserve that only for the most severe circumstances, where it is an absolute last resort. When you start saying all these things are armed attacks, you're really breaking down that restriction, because all of a sudden you say, okay, well, if narcotics smuggling is an armed attack, are economic sanctions an armed attack? States have argued that in the past, specifically in regards to the United States conduct. The United States has always fought back hard against those arguments. You could argue are other sorts of things like migrant flows a form of armed attack, or maybe environmental consequences that have health consequences for a public as a result of one state's behavior or policies. Is that a form of armed attack that can legitimate a military response? You're really opening the door to all these other categories of behavior. And traditionally, the United States has taken a slightly broader view of what an armed attack can be than many other states, but has always been careful to say, yeah, maybe it doesn't need to be a severe armed attack. Maybe it can be a relatively limited exchange of hostilities, but it still has to have that character of being something like, or that has effects like, a bomb or a bullet or a conventional kinetic use of force.
I don't want to get into whether or not Venezuela was, responsible for shipping the fentanyl into the United States, but if it were, wouldn't that make for some type of reasonable argument? Look at all these people who are dying from fentanyl. Yeah, it's not a bullet. Yeah, they're not blowing up like a bomb, but it's a lot of carnage.
You can make that argument. People have made that argument before. But again, you open that door to arguments about the same things about economic sanctions, environmental effects, or a variety of other consequences where you could say very similar things with very similar consequences.
And in general, the U.S. hasn't wanted that either.
The United States hasn't, and the international community hasn't. It's really an argument that is a big departure both from U.S. practice and from international practice for exactly that reason of abandoning that distinction.
Okay, well, that's the argument. I guess where I'm trying to go with you today is it different to go after the commander? Is it different to go after the president or the king or the chairman than it is to attack broadly?
There are shades of difference. It can be different. Any sort of military response you have to justify as proportional and necessary among certain other requirements. You're not supposed to be going over strictly civilian targets. You're supposed to be targeting people who have a military role, and that you can plausibly argue, well, targeting these people advances my chances of military success. It's militarily necessary. It helps advance my self-defense if you're premising this all on a self-defense argument, as this inevitably does, because that's the main exception available to states. So it can be harder to make that argument in regards to a head of state as opposed to a operational military unit that may be aiming a weapon at the United States. It's a much more attenuated relationship.
What if the argument is, look, we want to take out the head of state, and then we think the problem will resolve itself?
You can make that argument, like you can make that argument about anything.
Yeah.
But it's a factual assessment. Do you think that's plausible or credible? And there are other complications involved. Heads of states have a certain degree of immunity in regard to state conduct for legal proceedings. There could be an argument, although I don't think it's necessarily an airtight one by any stretch of the imagination, that those immunities would also offer against other sorts of state behavior, including potentially military strikes. It is not the tradition to naturally go for head of states in military operations, at least as a first order, but it's not unprecedented. I mean, that is something that we saw the United States do in Iraq in 2003, more or less, that we've seen in other sort of operations where there's been a decapitation element. And so it's not entirely novel. I don't think the major point of distinction is targeting a head of state versus targeting a state generally. It just becomes a question of, well, how can you justify that as the legitimate target based off the facts and the circumstance and their relationship to the threat that you're addressing?
So it's not, for example, a specific war crime to target a head of state?
I don't believe so, no.
What about in this case where we took Maduro, we arrested him? It was not a targeted killing. Is there legal restrictions on something like that?
Again, it all boils down to, from an international law perspective, at least, this framework of, is this a lawful use of force? Because force was necessary to facilitate this kidnapping. And was that force necessary and proportional to the self-defense that you're accomplishing or the other legitimate objectives you're advancing in the course of the armed conflict? Generally speaking, I think there will be a general bias in favor of, quote unquote, abducting or arresting someone because it's not permanent like killing someone is, right? You have a greater chance of reversing and chance of an error, and things like that. So in some ways, you wouldn't want to set up a legal framework that
made it easier
encourages.
to kill.
Yeah, it makes it easier to kill than detain people. And I think that's something that on an international level, people have been leaned away from, although notably in the U.S. domestic legal system, that there actually has a framework actually has kind of emerged in that way, in a problematic way. The key consideration, though, here again is what sort of use of force was involved. Yeah, we didn't kill Nicolás Maduro in this operation. We did kill 80 other Venezuelans. That's pretty significant. If another country had killed 80 Americans, even if it was to arrest a legitimate criminal that happened to be in the United States that was facing legitimate charges in their country, we would call that an act of war, an armed attack. And I think Venezuela, to describe it that way from a descriptive matter as a legal matter, that they can make that assertion credibly as well.
I think it might have been a mix of Venezuelans and Cubans, but that probably doesn't change the...
Yeah, correct. Individuals on the ground. I don't think we 100% know. There are some Cuban security forces involved among those killed, but I don't think we have I have not seen a clear public accounting of the full distribution allocation of who was there.
I'd love to turn to prior examples. What are your go-to examples in the past where the U.S. has targeted a head of state? Something that we could look at as an analogy.
So the clearest parallel is the Panama intervention, 1989 to 1990. That is the case where the George H.W. Bush administration intervened at a much larger scale, had 20 to 30,000 U.S. troops involved, as I recall, essentially did occupy Panama for about 45 days, more or less, was engaged in hostilities, involved in a number of fatalities, both on the side of Panama and a number of U.S. fatalities, and then ultimately did capture General Manuel Noriega, who had asserted the leadership role, essentially exercised a coup in Panama, kicking out what the United States and most of the international community viewed as the legitimately elected government, which had been kind of a government in exile at that point, and eventually taking Noriega back to the United States for prosecution, where he was convicted, served out a sentence, and then actually, I believe, eventually also transferred overseas to serve an additional criminal sentence later in life before dying. That is it's a notable case because a lot of the legal precedents that came out of that case are the things that people prosecuting Maduro are going to be citing as they proceed in that legal case.
Yeah, I mean, as you mentioned, it was a greater use of force, more intense military intervention. More people, I believe, died. And in that case as well, we didn't recognize Noriega as the head of state. Here, there are some distinctions. There wasn't a coup. The argument was that the elections themselves were not up to snuff.
Yeah, I mean, essentially, yes. We had originally Maduro was elected in 2013 elections, where I think there were genuine questions about the legitimacy of those elections, but nonetheless, the United States, other countries did recognize him as essentially the president and head of state after those elections. Then there were a set of 2018 elections, which were seen as broadly illegitimate. Or after that point, although some people would argue before that point, there's a little bit of a discrepancy here about where exactly U.S. recognition policy changed and at which point it changed. But at least no later than January 2019, shortly after those elections, the United States and many of its international allies changed its posture and said, we no longer recognize the Maduro regime as the government of Venezuela. We recognize the 2015 National Assembly, which was the last sort of body elected in what were seen as generally fair and free elections, as being the only legitimate arm of the Venezuelan government. And at that point, they had elected somebody within their body to serve as interim president under a provision of the Venezuelan Constitution. That was Juan Guaido. Juan Guaido served in that capacity for a number of years. He was eventually removed by the National Assembly due to internal politics, the expiration of his term, the legal structures they were using in early 2023, if I recall correctly. And then at that point, the Biden administration shifted its policy back to say, well, we basically recognize the 2015 National Assembly as the legitimate government, or the only legitimate branch of the Venezuelan government. It was empowered to exercise a lot of the functions of the Venezuelan government overseas. So, for example, it was allowed to exercise control over, in the U.S., at least within the United States, subsidiaries of PDVSA, the state oil company, and was able to control litigation decisions and asset decisions on that behalf. It essentially appointed a committee to do that. That's something that's proving to be challenging for the Trump administration now as they try to wrestle with the global oil industry, I suspect. But that was the role as it split. Maduro was still the de facto authority on the ground, but the 2015 National Assembly, first under Guaido and then under sort of a little more ad hoc arrangements, exercised governmental functions outside of Venezuela in those countries where it was recognized. So in the United States and much of Europe and a number of other allied countries.
Scott, does this give some new teeth to not being recognized by a country like the United States? I'm sure in many countries they might see it as, a blow to prestige and not, perhaps a prelude to something violent.
Yeah, I mean, it certainly is a blow to prestige, and it does have real legal consequences. When you're de-recognized by another government, that government's legal system, in most countries, it varies a little bit country to country, but in most countries, that government's legal system defers to the usually executive branch that makes recognition determinations. And so in the eyes of its court system, you are not going to be able to exercise governmental functions. For some countries, that may not matter. But for countries like the United States, where most foreign governments have substantial assets here in the United States and substantial interests, it can matter a great deal because you lose control over those. Now, notably, for purposes of international law, the determinations of individual states actually is not determinative of what is actually recognized as the government. It's a kind of complex bifurcation about how we think about recognition. Under international law, the standard is what is known as the effective control standard. And that is essentially, look, if a regime is in effective control, meaning they're essentially in control of a state and it looks like they're going to stay that way, then it is what is sometimes described as the de facto government of that state and can exercise the international legal rights of that state, including notably consent to the use of military force. That applies even if other states may not recognize it having that capacity and give some other regime the authority to exercise other governmental functions within their own territory. And where the line about what's permissible and what isn't, in my view, as I've written actually recently in some academic writing, isn't very well defined. And that's kind of a bit of a space for manipulation and complication and confusion in regards to international law and policy in this regard. The key point here, though, is that there is a theory going around for a long time that the Trump administration could simply ask for the consent of the 2015 National Assembly, which it recognizes as the de jure government, to engage in a military intervention in Venezuela. And if they said yes, that would be enough under international law to authorize it. And that's actually not correct. Most countries would say no, because they're not the de facto government. Even if you recognize them, other countries are going to accept them as having that authority. And notably, the United States has actually accepted that too. In the Panama case, the legal advisor for the State Department said quite publicly, yeah, we couldn't just rely on the consent of the government in exile. That wasn't enough to allow us to intervene. Instead, they made that argument combined with self-defense arguments, which were the argument they most squarely relied upon, along with some Panama-specific treaty arguments relating to the Panama Canal that don't have any sort of parallel in Venezuela.
Do you remember what the self-defense arguments were? How was Panama attacking or threatening the United States?
Much more conventional. In Panama, you had a number of incidents where U.S. service members and their families and other U.S. personnel who were stationed there, because there was, even under the Noriega regime, a substantial U.S. government presence in the country precisely because of the Panama Canal and related relationships and treaty relationships between the two countries, had actually been physically attacked. They had been threatened. And in one case, I believe one individual at least had been killed, if I recall correctly, although I maybe have the facts slightly fudged on that. And then importantly, Noriega himself had said, we are at war with the United States, had declared it publicly. That combination of factors was really what I read the George H.W. Bush administration as hanging their hat on, as saying, this is the basis of our self-defense argument. They also put forward, and we do have support from the government in exile, and we do have these other Panama Canal Treaty related arguments involved, but the self-defense argument really did the most work there. And you know that because they file what is called an Article 51 letter. This is a letter that the UN Charter requires states to provide to the UN Security Council when they rely on Article 51, self-defense exception. And the George H.W. Bush administration did that.
I wanted to ask, because, when I was asking about the specific international law rules, there is this convention on the prevention and punishment of crimes against protected persons, internationally protected persons. And does that add certain protections for heads of state as protected persons?
I would have to go back and look at that specific treaty. I don't know it well enough off the top of my head. My strong suspicion is that there are legal obligations that my recollection is that has to do with obligations to protect a variety of government personnel in a variety of circumstances. I don't believe that would preempt, in the context of an armed conflict, the ability to categorically target, foreign head of state if you thought they were a legitimate military target. But I could be wrong on that. I would have to go back and look at it more closely.
Got it. And then within the United States, we have a rule or a prohibition on assassinations. Is it sometimes in effect, sometimes not in effect? What is going on there?
Yeah, it's a matter of executive branch policy. The past presidents have adopted, and more recent presidents have more or less sustained a policy against assassinating foreign leaders, or foreign assassinations really generally. The key point here is that it's always been construed to not apply to legitimate targets during wartime. And so if you believe you have a legal argument as to who you're attacking as a legitimate target in an armed conflict, then this restriction wouldn't apply. It wouldn't be considered an assassination for purposes of that ban. You can disagree with that assessment, but notably it's also an executive order. It is a president-defined policy. So generally speaking, the sitting president gets to determine where the lines are on a policy that's issued under his own authority. So I don't see that as, that's more of a, I think, a tradition. It's a better way to think of it than a hard legal restriction.
And that's Order 12333?
Yes, and I believe there have been subsequent orders that have kind of built on that, but I think that's the original one. That sounds right to me.
Why don't we talk a little bit about arresting a head of state? I mean, this one, it sounds like it's maybe going to be the same argument that it's a legitimacy question, because there is a level of immunity that's granted to foreign heads of state. Are we talking about the same argument under a different umbrella here?
Yeah, I mean, here, because Maduro is going to be tried in a U.S. court, the U.S. domestic law implementation of international law principles like official immunity or acts of state immunity, official acts immunity, or head of state immunity, excuse me, really come into play here. And here, because it's a U.S. court proceeding, the way it played out in the Noriega context seems likely to play out here is that, at least in regards to head of state immunity, this is the immunity usually provided to foreign heads of state to any sort of legal process or to criminal or civil liability or legal process. The Noriega court took the approach saying, well, we're just going to follow U.S. recognition policy. And because the United States never recognized Noriega, then you would say, okay, then he's not a head of state for purposes of U.S. proceedings here. The international community may disagree. States may view it differently. They would say, no, he was the head of state and he was entitled to immunity, but the U.S. court legal system follows the recognition determinations of the president and the executive branch. Notably, Maduro is a little bit more complicated case, because whereas Noriega was never recognized by the United States as a head of state, Maduro was, until either, depending on how you read the facts, 2017 or early 2019. Somewhere in that spectrum, that recognition policy shifted. That matters because if there were conduct undertaken, or it potentially could matter in regards to particularly allegations and facts, although notably, that status at this point is rescinded either way. So I don't think it would prevent a substantial barrier, but it could matter in terms of how you view his immunity. That would matter more substantially in regards to official acts immunity, because that means there's a period where he was viewed as the head of state, and acts he took in that capacity could be seen as official acts, unlike if he had never been recognized as a head of state or as another sort of U.S. official of the Venezuelan government. Notably, the executive branch's assessment of those isn't necessarily categorically correct, and there is this kind of uncertainty regarding how official acts immunity extends to the criminal context. Although, if I recall correctly, I believe the Second Circuit has strongly suggested it does in recent years. So there is a variety of legal ambiguities there, but you could see it come into play there more often if the prosecution were contingent upon acts that were undertaken in an official capacity while Maduro was recognized as an official. Yep. Notably, the charges they brought are primarily conspiracy cases that extend up into the present day, in many cases back to the late 1990s and up into the present day. Because of those, you actually only really need one overt act, and you have the big pattern. And so even if the conspiracy only was
Scott, what do you mean you only need one overt act?
Usually when you're having conspiracies, you have to show an intent to collaborate, the mens rea to collectively be working towards an endeavor, and you have to show that an individual participated in an overt act towards advancing that conspiracy. And so when you're prosecuting someone for conspiracy, you don't have to necessarily show a super intense nexus of individual acts undertaken by each member of that conspiracy, as long as they took that an overt act. So in this case,
as long as that act took place during a period when he was not recognized, it should be fine.
I think so. It may, frankly, this is an area where I'm less confident, because I don't do criminal law as intensely as certain other areas. It's possible maybe the overt act doesn't matter. What does matter is the criminal conspiracy extended to a period for which Maduro's official acts wouldn't be immune. So I don't know whether the overt acts actual subject to immunity or not matters. I suspect it does, but I'm not 100% sure. But regardless, in this case, the conspiracy extended for several years past the period where, from the U.S. perspective, Maduro could engage in official acts at all. And they allege a number of acts that could stand as overt acts. And so I don't think they're going to have trouble making an argument in that regard.
Yeah, but I also don't. I won't be surprised that his legal team will have plenty of issues to raise,
Absolutely.
objections, and ways to kind of push this down the road a little
It
bit.
will be a law student's dream for a student note. So they should be watching closely.
Law students or law professors?
Both, possibly both.
Okay, depending on the student. Okay, so you gave a good example, or you gave the clearest example of another arrest. Are there examples of the United States targeting heads of state for assassination or, lethally?
It's a good question. In the Iraq invasion, if I recall correctly, I believe there were strikes taken against headquarters facilities by where it was believed Saddam Hussein may have been. So you could view that as, attacking a head of state or targeting a head of state. I don't know how central that was, how deliberate that was, or how much that was part of the, a deliberate policy choice by the United States. I can't think of any off the top of my head otherwise, on first blush where the United States took that dramatic step. And often that's because it was seen as highly escalatory. And again, you do, from a legal perspective, want to be able to make the clear case that this person has a role and we can tie them to the military objectives we're advancing and pursuing. But I believe those barriers are more on the political and strategic side than on the strict legal side.
So it may be just bad politics to kill a head of state. You're going to make enemies out of a nation.
Yeah, I mean, essentially, potentially, yes. I think that's probably right. And it is, to say the obvious, highly escalatory and probably often technically one of the more difficult things to accomplish, because usually states tend to protect their head of states pretty severely. That's part of the reason why this specific type of operation was so daring and surprising, is because they really went for it against probably one of the most protected targets in the Maduro regime, and they succeeded, to the military's immense tactical credit. Tactically, it was an immense success. It's quite impressive.
And you have to think it would have been so much easier if it would have been a strike rather than an arrest.
Presumably, yeah. I mean, certainly much less risk to U.S. personnel. That seemed to be a major consideration in the Justice Department opinion that we've seen come out subsequently. Is the view that, yeah, I mean, we acknowledge this comes with more risk to U.S. personnel than it would if a simple strike, but because the interest here is seen as not just removing Maduro, but capturing him and subjecting him to prosecution, that came into play and became a more justifiable outcome. But it'd be much easier to say we could just throw a missile at this person, and then no U.S. personnel would be subjected to any sort of risk. And under the domestic legal framework that's applied to these sorts of things, in some ways that's more easily justified.
Well, I wonder if we could turn the corner. It sounds like you're predicting, unfortunately for Mr. Maduro, his criminal case will likely go forward, and there will not be some silver bullet for him to get out of it. I'm curious, if there was an international law broken here, is there any recourse? I'm assuming that would have to take place in a subsequent administration where there was a willingness to participate in that. But if there was some type of path towards re-examining or examining this in an international body, where would that be?
It's a good question. The one thing I would say is I wouldn't rule out the possibility that there are domestic legal consequences of certain choices that could come about in the proceedings, whether it's Maduro's proceedings or potentially other legal proceedings, before you get to the international accountability point.
What do you mean by that?
So in the Maduro prosecution context, I agree. I think it's unlikely to get derailed by these sorts of barriers. There is a question as to, if you have an individual captured in violation of foreign laws, in violation of international law, arguments have been put forward that there might be circumstances where the usual doctrine that allows that person to be prosecuted is the Ker-Frisbee doctrine. It's been around for 150 years. Traditionally, that doctrine says if somebody arrives in U.S. jurisdiction, no matter how they arrive there, even if it's illegal, they can still be prosecuted under a legitimate prosecution. The Second Circuit did carve out for a number of years an exception to this, is the Toscanino exception that was subsequently somewhat narrowed, but does suggest, in cases where people engage in conduct that really does shock the conscience, then maybe that exception to the Ker-Frisbee doctrine can be overcome, and that would actually pose a barrier to prosecuting them. And this case is sort of different than that. The classic cases like the Alvarez-Machine case, as a Supreme Court case that kind of reinforced the Ker-Frisbee doctrine, extended it to federal personnel. It says essentially, well, that was a case where you had DEA agents actually go and essentially kidnap someone from Mexico and remove them to the United States over the objections of Mexico, saying they violated international law, they violated Mexico's domestic law, and they violated an extradition treaty with the United States. In that case, the Supreme Court ultimately said, on the Ker-Frisbee basis, we're not worried that this is not a barrier to prosecuting this person.
Let the governments fight it out, but it's not going to keep you out of jail.
Yeah, essentially, yeah. There might be other consequences, but it's not going to interrupt this prosecution. But that case is distinguishable from this one because it's different to invade a country, kill 80 people in that country to remove somebody versus kidnapping somebody. It's a greater violation. Now, does it rise to the level of the sort of shock the conscience conduct that the Toscanino exception, if it's even still valid, which we don't know if it is because it has never really been used successfully. We don't know, but I'd be surprised if Maduro doesn't argue it, and there's a possibility there. There's also there's a whole domestic legal framework governing the use of force that is implicated in this, that you could see legal challenges to, and we can get into that if it's of interest. That might have another different form of accountability for the president, not or other people around him, limiting their. And
where are you going with that?
Yeah, so in the United States, the executive branch's view on when the president can use military force, which is the view that essentially governs U.S. military operations, because courts have traditionally been very reticent or have just not been presented with many cases to second guess or evaluate that standard put forward by the executive branch. In its current format, it basically says, at least where Congress has not legislated otherwise, that's an important caveat that we can circle back to, as long as the action is pursuant to U.S. national interest and can be reasonably determined that it will not lead to a conflict whose nature, scope, and duration will rise to the level of a war for constitutional purposes. That is a term of art that generally means something like a major conflict that is prolonged, extended, and means substantial risk to U.S. soldiers and U.S. nationals. Then the president can do it on his own authority. For major wars, long wars, you need congressional authorization. The executive branch has at least acknowledged that possibility in recent years. It hasn't always, but it has since at least the 2011 Libya opinion, where this standard was articulated and did under certain prior administrations. They said maybe we need Congress for those, but for lesser military operations, we can do it on our authority. That's the test that the Trump Justice Department applied and said that this falls under, and it does fall under that pretty readily. This military operation is way smaller and way less risk to U.S. soldiers than even the Panama intervention was. So you can see why they would arrive at that conclusion. But there are other questions that arise from aspects of this case. The first is the second wave question. President Trump threatening and using a second wave. If he were to need to do that and deploy troops on the ground, something he said he wasn't afraid of, that he was willing to do in the Venezuela case, that poses a much more complicated question of legal authority, both because maybe that nature, scope, duration threshold, you start getting a lot closer to that when you're talking about occupying a foreign country without congressional authorization, large scale of troops. Also because if that military operation lasts longer than 60 to 90 days, then it hits the zone where the War Powers Resolution Congress enacted in 1973 says you need to go to Congress to get authorization or you need to terminate that military operation. That line is significant because once you start acting in a manner that's contrary to a statute, that's the circumstance where federal courts have said, well, we actually do need to take up cases in this sort of circumstance. Up until then, we usually say they're non-justiciable, they're political questions. But when you start acting contrary to statute, we think they're justiciable, and we even have an obligation potentially to intervene there.
But Scott, that's only, you're talking about a scenario where this does turn into more of a traditional war, where we're deploying troops.
Yeah, that would be the second wave scenario where I do think there are real limitations there. And we also have the congressional action.
Without congressional authorization.
Without congressional authorization, exactly. And we do have congressional resolutions that are being debated, although I don't think any of them have a viable path forward right now that could impose additional limitations there even before you get to that point. In regard to the maritime strikes, there's one other avenue of domestic legal question accountability that I think is worth raising, which is the fact that those conduct arguably run contrary to a different set of domestic statutes in the United States. That's murder statutes.
Got
Um,
it. This is where the people were maybe waving for help, and there was a second strike.
really any of the maritime strikes.
Any of them.
Because U.S. murder statutes, there's a variety of statutes that apply to conspiring to or actually executing lethal attacks on people overseas. And the usual reason why the executive branch interprets those as not applying to military operations overseas is because of what's called the public authority exception, which is that where officials are acting pursuant to public authority, then that does not constitute murder. It's not an unlawful killing. It's okay. It doesn't violate these sorts of statutes. That came up in the Anwar al-Awlaki case, where it was a U.S. citizen who was targeted for a targeted killing during the Obama administration. There's a long OLC opinion that's mostly available exactly regarding that case. Here, it's much harder to square those maritime strikes with the public authority exception for the simple reason that at least when the Obama administration tried to justify its actions under the public authority exception from the Anwar al-Awlaki case, they said, look at past U.S. military practice, look at international law. Everything we're doing is consistent with these things. So it's well established this is within the public authority exception. In the maritime strikes case, you can't make that argument. The United States has never targeted criminals before for lethal activity like this, flat out. There is not that pattern of past conduct that's easy to tie yourself to. It's a novel step it's taking here. I think that raises big questions as to whether this is within the scope of the public authority exception. Notably, the Justice Department opinion that came out regarding the Maduro operation hints at the legal arguments that the Trump administration Justice Department is invoking in regard to the maritime strikes. It strongly suggests it's basically saying if you follow the orders of the president, that's enough to qualify for the public authority exception. But that's not a view that's ever been vindicated with the courts. So I do think there's a question here about, could there be a federal murder violation here? Now, I don't think the Justice Department or the Trump administration...
We know that the president has special immunity for anything that he does under color of the office. So what, we'd arrest the soldiers, but not the administration?
There could be people involved up and down the chain who could be in pursuit of violating the statute. Now, I think it's highly unlikely they would ever be prosecuted by this administration. The president could issue a pardon before leaving office, so they may never face criminal prosecution. But I do think it's implicated in the prior question I mentioned about, well, what is the president's constitutional authority to undertake this? If he's taking action that directly violates a statute, then that's the sort of situation courts say that they're supposed to take up. And I think that's a factor why, if you saw the maritime strikes actually get a plaintiff who could bring them before U.S. courts, that might be one factor weighing towards greater risk on behalf of the executive branch to say, well, can we really count on the courts not reviewing and taking up this issue? And I would be less confident about that in the context of the maritime strikes than I would be, for example, about counterterrorism strikes that have been taking place since 9/11 in a much more conventional fashion towards much more conventional military targets.
While we have you here, I'm curious your thoughts on the legality of another aspect of this Venezuela campaign, which is, since the campaign, there's been varying statements, but one of the most iconic was, "We're going to run it," by the president. How have you thought through some of the legal issues here in exercising direct authority over a sovereign nation?
Yeah, it's absolutely fascinating. And part of it is because the Trump administration is using rhetoric that doesn't line up with what it's actually doing, in a way that you've seen Secretary of State Marco Rubio try and correct this a little bit from the president's initial statements on January 3rd. The president sounded like on January 3rd saying, we were going to exercise direct control over Venezuela, or we're going to run it, I'm going to run it. He said similar things like that in subsequent days. But what Rubio and others have clarified, and this does appear to be what's happening on the ground, is that they're essentially saying, we're not going to run Venezuela. Delcy Rodriguez, who had been Maduro's vice president, is now the interim president, is going to run Venezuela. And she is going to comply with this list of conditions, or else we are not going to allow oil sales to continue. We're going to continue our embargo of Venezuelan oil, which has been continuing since before the Maduro operation. There could be this potential second wave the president has threatened, although Rubio was much cooler on that idea. A number of other measures could come into play that would be additional pressure. So they essentially are saying, we think we have a proxy or a puppet in the Rodriguez regime, and we trust they're going to implement our policy. And so far, it seems to kind of be working. There is genuine cooperation happening between the Rodriguez regime and the Trump administration, particularly around oil revenue. We've seen oil sales of kind of stockpiled Venezuelan oil that they couldn't sell during the embargo and under sanctions now get released, and that fund is going through an arrangement set up by the Trump administration through a set of accounts in Qatar, essentially, and that there's reasons for that, which I can get into a little bit.
Why could Qatar or
so it's a really interesting set of patterns that actually ties back to some real complications in the United States. In the past, when the United States was in a similar situation, particularly in 2003 after it invaded Iraq, and it wanted to help Iraq get its oil industry back up online, it installed a set of extraordinary legal protections for it under the International Emergency Economic Powers Act, a very broad statute which gives the president very broad authority from Congress about regulating economic relations with foreign parties, to basically say nobody with a civil judgment against Iraq can try and attach or seize these assets coming in. They're instead going to go through a special account of the development fund for Iraq. That was important because Iraq, like Venezuela, had tons of commercial creditors trying to claim its money from years and years of legal disputes. And that was protecting those assets was important to make sure Iraq actually got the money it needed from this oil revenue to be able to begin to rebuild. And that's the same challenge the Trump administration is wrestling here. But they're facing a different complication in that Venezuela has all these relationships with the Trump administration, has been among the most vocal people about articulating with groups that are designated foreign terrorist organizations, some of which predate the Trump administration, FARC, ELN, these are Colombian terrorist groups.
So
and
US
some of
banks
which
can't touch it.
No, it's more complicated than that even. It's not that U.S. banks can't touch it. It's that when you have claimants with claims against a foreign terrorist organization, of which there are many in the United States for groups like FARC, which have hundreds of millions of dollars, if not billions of dollars in judgments against FARC and some of these other terrorist groups. There is a special exception called Section 201 of the Terrorism Risk Insurance Act, which says when assets are blocked or frozen pursuant to IEPA, the International Emergency Economic Powers Act law I mentioned before, claimants can attach those assets and notwithstanding any other provision of law, meaning sovereign immunity doesn't matter. None of these other restrictions matter. It's an almost absolute right to attach those assets. So that means if these assets were in the United States, precisely because of these ties with FARC and these terrorist groups and the Trump administration's to designate lots of groups like Tren de Aragua and the Sinaloa cartel as FTOs just in the last few months, people with claims against those groups very well could attach them against PDVSA's assets and Venezuela's assets, because TRIA has been interpreted as allowing super broad seizure even against groups that just provide material support to the designated FTO.
So we're going through Qatar to keep people from jumping the line?
I think that's basically right. They're saying if we keep it in Qatar, we know U.S. claimants aren't going to be able to get to it. If we bring it here, there's at least a real litigation risk. And notably, they're not the first ones to do that. It's the same thing the Biden administration did with Afghan central bank assets after the collapse of the government there. When you saw a lot of claimants come forward with claims against the Taliban trying to attach those assets, the Biden administration took half of them, moved them to Switzerland in a kind of private foundation sort of arrangement and said, these assets are going to stay there for the Afghan people and be preserved for them. And they had to move them out of the United States to do that. The other half of the assets are tied up in litigation around Section 2.
So Biden moved them to Switzerland and Trump moved them to Qatar. Had nothing to do with the free airplane.
So it might have, but there's one other factor that enters in here as well, that comes in why Europe probably is not a good place to do it. And it comes to another internal contradiction in the Trump administration's management of all this, which is that, as I mentioned earlier in our conversation, since 2019, the United States has recognized not the Maduro regime, or now the Rodriguez regime as the government of Venezuela. It's recognized the 2015 National Assembly, which is led by the opposition associated with Machado and other figures. And notably, a lot of European allies and governments followed the United States lead on that under heavy pressure from the Trump administration. So I don't know Switzerland's specific laws, but in a number of European countries, as in the United States, if these assets came into those countries, it would not be the Rodriguez government that controls them. It would be the 2015 National Assembly. So the Trump administration would either have to get the assembly on board and would have multiple groups it has to deal with. And I think we can see its relationship with the opposition movement is complicated now. The Trump administration has not been as intent on facilitating an election and transition to their authority as some would like to see, including Republicans in Congress, among others. And so it would cause this complication. And the Trump administration could resolve some of it by saying, well, we're going to switch our recognition policy back to the Rodriguez regime, and we're going to try and get our European allies to do the same. But that's going to be a real diplomatic undertaking, and it's going to be controversial among supporters of the Venezuelan opposition in the United States, including a lot of Republicans in Congress. There's lots of political reasons why that
Yeah.
is a harder shift to make.
Okay. All right. So we're going through Qatar in order to avoid these claimants kind of gunking up the flow. I mean, I'm imagining there's claims that go all the way back to Exxon being kicked out, or targeted killings during Chavez.
Yeah, no, exactly right. I think most of the commercial claimants, the Trump administration could use IEPA to block those from being enforceable, like they did with Iraq and the Development Fund for Iraq. But it's these terrorism claimants, of which there's a lot, that IEPA can't be used to protect because of Section 201 of TRIA, the way Congress has set up this regime in the United States. And for those, that's why the money's overseas. Plus, it lets the Trump administration avoid having to resolve this inconsistency in its recognition policies. And then the only question is why Qatar? But notably, the Qataris have actually done this before. It played a similar role in regards to Iranian assets that were held up and going back to Iran. This was money owed to them by South Korea and, if I recall correctly, Japan. That ended up being part of a hostage deal the United States negotiated with the Iranians under the Biden administration, where basically the money was held in a Qatari account and was only given to the Iranians to be spent on certain humanitarian goods, essentially, and services, like a discrete category of purposes. And the Biden administration seemed to be pretty comfortable with the level of transparency and coordination it got from the Qataris on overseeing that money and made sure it was used for that purpose. My guess is that familiarity and comfort translated to the Trump administration as well, because the career officials at the Treasury Department, at the State Department working on this probably know a lot of the same actors and said, well, this worked in this other case. It will probably work for Venezuela too.
Scott, and if this isn't your specialty, I know you can't know all.
I can try though.
Yeah. I'm curious, what structure is in place on spending that money or distributing that money? Is it just how the administration thinks is most useful?
So that's something that's a little bit unclear. It's clear that Marco Rubio and other U.S. officials are going to be a central role in kind of determining how that money is allocated, apparently with the cooperation of the Rodriguez regime. Like if they disagreed and there was a lawsuit over, who controls that money, it's not clear to me the United States would effectively establish title in most foreign court systems. But regardless, they seem to be having the cooperation of the Rodriguez regime at this point.
Under some level of
duress. Yes, exactly. I mean, it's not entirely voluntary, but it's probably voluntary enough for present purposes. There's a sense that a good chunk of that money is going to go back to the Venezuelan central bank, and there's clearly steps taken in the executive order President Trump issued, I think like a week and a half ago now, about these assets to help insulate them from protection so that some of those money can come back to the United States. And probably serve as, essentially foreign reserves or other purposes for the central bank, fund government activities. And a lot of that money is going to go back to PDVSA to be reinvested in the Venezuelan oil sector, because part of this is they want to renovate and upgrade that and up the flow of oil. Venezuela is widely understood to be wildly underproducing the amount of oil it could be producing. And many global actors, not just the Trump administration, but the Trump administration as well, want to produce more because that will lower oil prices, provide a cheaper supply to the United States, potentially give business opportunities for U.S. oil companies. And then there's the potential some of that money could be used to pay claimants, particularly among oil companies who say the Venezuelan government expropriated their property back in 2007 and 2008 under the old Chavez regime. It's not clear to me how big a part of the picture that is yet. We've gotten kind of conflicting accounts. President Trump talks about those claims. Yet in other cases, he's said, well, to get that money paid back to you, you're going to have to reinvest in Venezuela. Or at times it said your compensation will be opportunities to invest in Venezuela. So we don't 100% know.
I wouldn't be surprised to see some strings attached on that.
Yeah, definitely a possibility.
All right. So I'm curious going forward, what has this changed? Has anything changed based on this arrest of Maduro? Has this affected your understanding or the global understanding of international law when it comes to targeting a head of state?
So it is certainly a dramatic step that the United States has taken. From an international law perspective. This is a state-on-state use of force. There is the self-defense arguments the Trump administration could make, which notably it hasn't yet, at least that I've seen. But it does seem like it could make a very similar argument as it made to the maritime strikes regarding Article 51 based off of narcotics smuggling in regards to Maduro. the international community is not going to view that as legitimate. Like I said, it really stretches the bounds of credibility. But at least it would be an argument available to it. And it would be suggesting the United States still accepts the general UN framework, even if it interprets it in a way the rest of the world isn't on board with. So far, the Trump administration hasn't taken that step. I suspect it will at some point. With the maritime strikes, it took almost a month and a half after the first strike before the Trump administration finally made its speech to the UN Security Council that laid out its international legal justification. I still think the Trump administration is likely to do it here because at some point it's going to need to get international allies to at least accept and move on from what it's done in Venezuela if it's going to want to be able to sell oil or normalize relations or otherwise do the various things it says it wants to do with post-Maduro Venezuela. And to get them on board, it needs to at least nod to the fact that there is still an international system that those countries, most of whom really value, and that many of them actually even have domestic legal obligations under the legal system to comply with.
Scott, it seems like kind of a cynical system. If you're powerful enough, you can avoid the rules and then just make some lip service to it a few months later and move on.
That's one way to view it. And look, no one's going to argue that this is good for international law or for the general prohibition on the use of force. But I think there are real consequences that come to the Trump administration too, and that they're going to be wrestling with for the next few months. Its situation about how to deal with Venezuelan oil sales is going to be really complicated by the fact that a lot of states are going to see what's happening as illegitimate. You are going to run into all sorts of questions about intelligence sharing, coordination that were already becoming an issue in the Caribbean because of the maritime strikes, where you saw the UK and other countries cut back on traditional cooperation. That was really important to U.S. conventional counter-narcotics operations, among other regional objectives. You could see that happening at a larger scale now in other cases. But notably, the Venezuela case, I will say, while I think legally it really does raise really serious questions that should be taken seriously, from a policy perspective, a lot of countries are likely going to find it a less bitter pill to swallow than certain other bitter pills. Because Maduro was a problem and he did a lot of very bad things and he was a regional actor that caused issues. And they will say, well, maybe a post-Maduro Venezuela, some good can still come out of this. That doesn't mean they're going to accept what they did as legitimate. There's still going to be an argument here. There's still going to be costs for the United States of taking a step that many states are going to view as illegal. But my guess is it's not going to be as, like I said, as bitter a pill as certain other circumstances could be. You look at the European reaction to Greenland. That is a pill that is too bitter for them to swallow, and they have reacted very, very strongly. I still think that will is there, and that reflects the fact that there are still real international legal norms that pushing too hard against them does come with big, big consequences for the United States, even states as powerful as the United States. Just is this case the straw that's going to kind of break the camel's back of the international system? I'm less convinced of that of others. Doesn't mean I think it's good. I don't. I think it's a problem for the international system and relevant norms, but I think those norms and values and legal principles have survived frankly worse in the past, not least the Panama and Iraq interventions. So
in this case, very few people are out there truly team Maduro.
Exactly. And like for better or for worse, international legal considerations are often a significant and important, underappreciated, significant, important consideration for foreign governments. The United States doesn't appreciate that enough, particularly under this administration, but it's not the only one. It's going to enter into a bunch of other interests and considerations those states have to weigh, and that's going to craft their national response. And, with Maduro, there's lots of other factors on the other side that are, like I said, going to make this easy to ultimately acquiesce to and move on from, if never accept as valid and legitimate.
Does this give additional fear to someone like Volodymyr Zelensky that, look, the precedent has been set again recently that when you're at war, you can go after the head?
Yeah, absolutely. I mean, Zelensky, I think is well aware of that. What was done against Maduro is very similar to what Vladimir Putin tried to do against Zelensky in a much more lethal fashion when they launched the invasion. Remember, one of the very first thing they did was to try and decapitate the Ukrainian government in Kyiv. It is a really, disturbing step from a lot of people's perspective that a state would be willing to take this step and not feel the need to validate it under international law. That is, again, a reason why I think the Trump administration ultimately is going to make an argument about why what it's doing is consistent with international law. And while that may not be persuasive to many states, it will be better than saying we don't have to abide by international law at all. But, you're still weakening those legal restrictions. You're still opening the system up in a way that would make me very nervous if I were Taiwan or Ukraine, not least because also the Trump administration has subtly signaled in other ways we might be more open to China and Russia asserting themselves in their spheres of influence, in which those countries arguably are within, in a way that the United States did here. And those sorts of parallels are hard to avoid. So I do think it's discouraging. The legal consideration is just part of that. The policy considerations I think, are also a big consideration for those states as well.
All right. Anything for us to look at, to watch out for on the legal front?
I really would just keep an eye on how the Trump administration frames what it's doing and takes its approach to the post-Maduro situation in Venezuela. I fully expect the Trump administration to eventually make an international legal argument, and it making that argument is going to be a significant step towards trying to get other states to move on past this development. Importantly, that is also going to have to resolve this recognition question. How are you going to actually deal with this new Rodriguez regime? Is it the recognized government of Venezuela? Is it not? What role does the opposition play? That's something this administration really has not given public signals on at all. They're going to have to come up with a plan on it. And they're going to have to do it soon because at least one federal court has requested that they submit a filing clarifying their policy in regards to the recognition of Venezuela by early February. Now, they can probably get an extension. They probably will seek one and get one. But at some point in the next several months, they're going to have to come up with some clarity and a plan there. And then the real question is, watch what happens in Venezuela. The Trump administration has put a lot of skin in the game on a very, very narrow plan that seeks to do a whole lot with a really little commitment. Those are really tempting bets to make because the payoff is huge when they succeed, but there's a reason why they often don't succeed. And then the question has to be, well, how serious is President Trump about a second wave and greater military action? And how feasible is that in terms of congressional support? And what it would actually take to pursue that sort of military action? I'm highly doubtful that that is likely to come forward. And then what happens with Venezuela? Does it become a failed state? Something that would be really, really disastrous for a variety of other U.S. policy equities in the Western Hemisphere.
Right.
So it really is, so far, frankly, the Trump administration policy seems to be working out okay. And maybe it will get there, but it's early in the game. And we're not really going to know the ramifications of this choice for many years. And there's lots of ways that the ultimate outcome might be a lot more troubling than what we're seeing today.
Scott Anderson is a fellow at the Brookings Institution and a senior editor for Lawfare. Scott, this was a real pleasure, and I think it's a treat for our viewers and our listeners, even those who like to listen normally at 1.5x speed on our podcast. They won't need to.
There you go. Yeah, it's hard. It's hard when I am behind the mic here, but there's a lot of ground to cover in this particular case.
You covered a lot. A lot, and we're very appreciative. Thanks for the time.
Appreciate it.